a reasonably diligent visual inspection. You've got to disclose what you see in the inspection to the buyer, and you may even have to go a step further than that if you're the fiduciary agent representing the buyer, or if you're a dual agent. We'll cover that here in a second when we go to the AVID. Home equity sales contracts. Anybody know what they are? Yes? No? All right. If you are involved in a property where there is a notice of default of record at the time that you are taking the listing, as of the time that you are writing the offer, whatever it is, you have to use a specific contract, because your buyer is what's known as an equity purchaser and your seller is known as an equity seller, and something slams into effect when that notice of default is recorded, and it's called the Home Equity Sales Act. Anybody familiar with the Home Equity Sales Act? Sort of? Yes? No? All right. Home Equity Sales Act is it's kind of a bear trap of a law that's out there. And what it's designed to do is it's designed to protect people who are selling their homes that are in foreclosure, that have defaults, from being taken advantage of by, shrewd, sharky people that swoop in there and steal their equity. Not as big a problem probably today, because I don't think most of the people that have NODs recorded have any equity in their property. But that still doesn't mean you don't have to comply with the law, and here's why. What the law says is if you are going to write an offer for a buyer on a piece of property with a recorded notice of default against it, and again, this only applies to residential property, owner-occupied, 1 to 4 units. But if you do this, you've got to have specific language in your contract. And that language is meant to tell the seller a couple of things. First, they have a cooling off period. One of the things you don't normally get in California is a cooling off period for a contract. But if you are an equity seller, you have a notice of default recorded, you have 3 days to consider whether you want to take any offer that you have actually already accepted. So you have this 3-day cooling off period. Then there's other things that the law talks about, other rights that the equity seller has that they want the equity seller to be aware of. So you've got to use a contract that states this information in it. Luckily enough, CAR has one for you. It's called the Notice of Default Purchase Agreement, the NODPA. It's in there. Take a look at it. It's pretty good. But here's one caveat. If you are representing a buyer who's going to buy a piece of property with a notice of default recorded in it, you have to ask yourself and ask your buyer, what are you going to do with this property? Because if you're going to live in it, and if you're buying it from a guy who's living in it, and you're going to live in it yourself, you're fine. You can just use a stock, good old CAR, RPA-CA, and you're fine. If you're buying it for an investment purpose, and you're buying it from the guy who lives in it, you got to use this contract. And if you don't, there's a number of things that can happen to you. One is you can get sued big time. And if you get sued, there's a real good possibility that your E&O won't cover it, because it's considered to be a violation of a statute which most E&O policies either don't cover or they don't cover fully. You'll be defended under what's called a reservation of rights, which means they'll defend you, then they'll come back and ask you for all the money back that they spent on your defense, and they won't cover any damages that are assessed against you. The classically bad example of this is you represent the equity buyer, buys it for less than market value, gets a really good deal on it, let's say gets it for $30,000 under market value. The court will turn around and say, well, give the $30,000 back to the buyer, back to the seller, which you didn't even have in the first place, but nevertheless you got to give it back. Plus, we're going to multiply that by 3, make you give that to the buyer or to the seller as well. And then depending on how your conduct was, we might assess you with attorney's fees and what are called punitive damages, which I think we talked about last time. That's the slap on the wrist. So it's a law that you really want to comply with if you can. And here's the last yes?
If you're in escrow, or at least you're under contract on a property that's a short sale and an NOD gets placed on it during that process?
Yes.
What do you do? Because now we have to use this for.
Well, that's a really good question. And that's a question that's been asked a lot, which is, not every property that's in default is in default when you take the listing. Maybe you take the listing and you pull up, preliminary report and it's clean. And then 4 weeks later, the lender decides, hey, I'm going to record my notice of default. So what do you do? I don't know. If you were to come to me and say, what do I do in this situation? I'd say redraft the contract and put it on a notice of default purchase agreement with an addendum saying this contract supersedes the previous contract and is being re-executed by the parties because a notice of default was recorded. That's what I would do. Is there a law that says you have to do that? Absolutely not. Is there a case anywhere where the judge said you got to do that, or a judge slapped somebody on the hand for saying you didn't do that? No, absolutely not. So do you have to? I don't know, but it would certainly be the wise thing to do would be to redraft it on the NODPA. That got the person next to you riled up too. So okay, yeah, let's. I have good news for you. You don't have to worry about if it's income property. If it's income property, it doesn't qualify for the Home Equity Sales Act. Only time you have to worry about the Home Equity Sales Act is if you are representing the seller who is occupying the property. It's residential property occupied by the seller.
Yeah, but the seller's living in one of the units.
Oh, okay, I see. So you're talking about like a duplex or a triplex or a fourplex or whatever. So how do you merge that along with the NODPA?
Yeah.
I guess what you would have to do is you fill out the NODPA and then attach the income producing contract as an addendum and say this is the contract for the residential purchase, and then please see the additions on the whatever they call it, income producing contract as an addendum. So do something like that. That would be a tricky one, and if you were doing that, I would say come to this man here and let him work his magic on it as well. Yes, in the back.
If the buyer intends to occupy the property, is this form required?
No, it is not. Again, if the buyer, it only applies if the buyer is an investor. And here's the last issue that we have with this particular law is that there's a provision in the law that says if you're going to represent the buyer, and the buyer is going to be an investor purchaser, and you're making your offer to the seller who is living in the property, you have to obtain a bond. And if you don't have this bond, it doesn't matter if you do everything else correctly. If you don't have this bond, you've still violated the act. That issue was litigated last year down south in Orange County, which happens to be in the 4th Judicial District of Appeal, and I'll tell you why that's important in a second. Because that's exactly what happened. A buyer and a seller got together, did a deal. Seller was the owner, resident of the property. Buyer was an investor. They went ahead, did the deal, sold the property. Seller got mad afterwards, said, I don't think I got enough money out of it. Went to an attorney. The attorney said, well, they did everything correctly. They used the CAR NODPA contract. Everything went smoothly, but the selling agent didn't have the bond. Anybody know why the selling agent wouldn't have the bond? Jim knows.
Can't buy it.
Right, can't find the bond anywhere in California. There's no bonding agency that'll issue it. And the reason that nobody will issue this bond is because the law is so poorly written that no bonding agents can figure out what it's supposed to be. How much is it supposed to be? Who is the bond supposed to be in favor of? What kind of bond is it even supposed to be? Nobody really knows. So no bonding agencies will write it. And when the 4th District Court of Appeal got a hold of that, they struck the bond requirement, saying, well, if no one can figure it out, then it's what we call unconstitutionally vague, and you can't really bind people to unconstitutionally vague laws. So they struck it, saying it doesn't apply. The rest of the Home Equity Sales Act absolutely applies. The bond does not. Here's the problem with that for you guys is you're in the 2nd Appellate District. You're in LA. We down in San Diego, we're part of the 4th. Orange County is part of the 4th. Mammoth Lakes, for some reason, is part of the 4th as well. I don't know, it's kind of a weird district. But unfortunately, LA, Santa Barbara, Ventura, you're all